Thanks so much. I'd like to thank in particular all of those who are participating and all of those of you who are attending from wherever in the world you may be. This is the next installment in our series of SIAC webinars about international arbitration in the age of COVID. I know that all of you have had different experiences in different parts of the world, and that's one of the reasons that in this particular installment of our series, we tried to focus on one part of the world, the Americas, where I know there's been extensive experience both in Latin America and in North America with virtual hearings or remote hearings, depending on your choice of vocabulary. In addition to thanking those of you who are attending from either of the Americas or elsewhere, I want to give special thanks to our panelists. We've put together an extraordinary array of talent from all of the Americas. You can see the names of the various participants, the panelists on your screen, and they require no introduction. Karina Goldberg, Maria Shadid, Nigel Blackaby, Fabiano Robolin, and Eduardo Zuleta. I think collectively between them have probably more than a century of international arbitration experience. And I know that in at least some of their cases, they have extensive experience either on my side or against it with remote or virtual hearings. We're going to hear from them today about their experiences, but we're also particularly interested in your views, the views of the attendees about virtual hearings, either by way of questions or observations, comments to which various of our panelists can respond. I'd like to start by asking Karina if she could say some words about her experience in Brazil and elsewhere with virtual hearings, and then we'll move to Nigel, who I know has, if I can put it this way, a mirror image or reverse set of experiences in similar circumstances. Why don't we though start with Karina?
Okay. So good morning, everyone in the Americas. I think good afternoon for you, Gary, and good evening for the team in Singapore. Brazil has been actually friendly to virtual hearings. We had few discussions here on whether our arbitrators should move forward, even if there is no consent among the parties to have the main evidentiary virtual hearing. And if Brazil is the seat, and if the governing law of the arbitration is Brazilian law, three main considerations are taken usually. And so the fact that our arbitration law does not provide for the need of in-person hearings or physical appearance, and quite on the contrary, actually our civil procedure code currently has a specific provision that allow the use of technology and allow judges to schedule virtual hearings. So since the beginning of the pandemic, courts have enacted their own regulation to support virtual hearings. And that's why I think that courts are, and the legal framework here are familiar to remote and virtual hearings, even virtual trials. And this is being also very helpful to arbitration. Arbitration law in Brazil also gives power to arbitrators to decide on the procedure path, including taking of evidence. That's why it's being helpful here in Brazil to continue arbitration proceedings and having a virtual hearing international cases. As per my personal experience, I'm optimistic. I'm not concerned with ethical behaviors, mostly because of arbitrators and counsel. And Gary and Nigel and myself, we had an opportunity to have a big evidentiary hearing. And in the very early days of the pandemic, we had the first week of hearings with factual witnesses, cross-examination and presentation by the parties. And we had to convert into the hearing to a remote hearing. Everybody flew back home. And of course that we had to adjust, we had to adapt, and we need shorter cross-examination sessions. And we needed to reduce the number of witnesses. So we chose, every party had to choose, each party had to choose and to drop some of the witnesses. And we had to have one principal speaker to avoid interruptions. But it worked well. So we didn't feel that it was harder to assess dishonesty, or we had no issues with witnesses' behavior, and I think that this may be the tendency, because here in Brazil the pandemic is still going on, so arbitration needs to continue, and we have a friendly atmosphere to avoid claims of due process and attempts to set aside awards based on the fact that the main hearing is virtually.
That's very helpful, Karina. What's your prognosis for life after the pandemic, assuming that we ever get back to something approaching normalcy? Do you think we'll continue to see virtual hearings in Brazil?
I think that in-person hearing will still be the rule for evidentiary testimonial evidence. There is no, it may be considering international cases because of the reduction of costs, and because we are being able to reach efficiency through remote hearings. But I believe that parties will still be comfortable with the main hearings being in person, especially because of factual witnesses.
Yeah, Nigel, I think you had as I mentioned previously, a mirror image, or at least other side of the table perspective on pretty much the same set of questions, the same set of procedural issues. Your perspective, both from that experience, but otherwise. What's life like as counsel in new virtual or remote contexts?
Thanks, Gary, and hi everyone. Yeah, I think it was an experience that worked very well. Focusing specifically on the evidentiary hearing, I've had several other hearings of a procedural nature since then. I think obviously a lot depends upon the professionalism of counsel, and so I'm happily we were working with professional counsel all around, and with a strong tribunal, and I think that helped to keep the hearing on track. I think that becomes even more important in a virtual hearing, that the president takes a firm hand, controls the process, doesn't allow it to get out of control. So I think it worked. I think it worked well. I mean, I think clearly there are a number of issues that need to be taken into account when doing it. I think from a sort of a purely process nature, it's really important that everyone understands how the system works. They're not complex systems, but certainly it's not just about counsel knowing how to operate the system, but does the expert who's alone in their lockdown or office or remote know what the camera angle is doing, what the background noise is doing, how to use the different functions. So I think it's some kind of sort of, on a big hearing, to have some kind of training. I think that would be really helpful. Make sure that people appear the same in their headshots, that one person isn't also staring up their nose, and another person you've got half their head cut off. That can sort of be off-putting in terms of just everyone having a similar appearance on the screen. But the dry runs and having a great tribunal secretary, I think as a rule, that the role of the tribunal secretary just magnifies and increases exponentially with a virtual hearing. I mean, they have to be IT specialist, organize everything, get things up and running, make sure that, I think if you've got a good a good tribunal secretary, that's key, I think, to making it run smoothly. And we were very lucky in the case we all did together that was the case. Again, other things I think obviously that you begin to realize is that when people are in different time zones, you can't have a 7-hour hearing day, because it's going to mean that that's unfair to some counsel. If it's 3 a.m. or 10 at night, they're not going to be on their best. Does it just favor the person who happens to be in the sweet spot of the time zone? So you need to think carefully about how long you run each day. And again, that was considered, and shorter hearing days were proposed. And I think also, going back to one of Karina's points, it's really important to think about actually what matters in the case. Who are the witnesses that really matter and are going to make a difference, as opposed to wouldn't it be nice to have everybody there since they're given a statement. I think you have to be more selective, because if you've got smaller hearing days, shorter hearing days, you're going to have longer hearings in terms of number of days, unless you start thinking about cleverer ways to cut down on actual hearing time. So I think it's a good example of having to think through, and for tribunals to actually think, how long do I want to hear this for? Half an hour, 1 hour, is it going to be enough? As opposed to sort of 4 or 5 hour cross-examinations, which just don't work in a virtual setting. They're just too long. So there are a few thoughts. I think there's some problems with the system, and which I can no doubt we can carry on and talk about a bit later, but there's some initial reflections, Gary.
That's very helpful. I think it would be good to come back and talk a bit about specific differences. What sorts of things, if you're cross-examining a witness, do you need to worry about that you wouldn't ordinarily have to worry about? What sorts of things, if I can put it this way, defending a witness, if your witness is being cross-examined, do you need to worry about? How does one deal with documents in a remote hearing? Are there special challenges, special opportunities? But before we come on to that, perhaps we can move north a little bit. Maria Shadid, I think, got up at 4 a.m. That's the record in this group, I believe. Maria, your view from the West Coast.
Thank you, Gary, and hi, everyone. Let me take us back to the start of the pandemic. We were one of the first states to lock down in the United States here in California. And what we initially saw in the international arbitration community was a flurry of dialogue and some anxiety, frankly, for about a week. And then very quickly, it turned to brainstorming and problem solving. And we saw a proliferation of draft protocols and testimonials. And many of us were participating in and tuning into webinars like this one with other counsel and with other stakeholders in the arbitration process. In my firm, we actually created our own internal virtual task force, virtual hearing task force that quickly came together and collected and recorded our team's own experiences with virtual hearings and external data and recommendations from the broader community. At the time, I had my own first virtual hearing. It was in my arbitrator capacity, and it was fairly early, again, about maybe in April. And frankly, having consulted so many resources, we felt very well prepared for the process. And as it turned out, I was far over-equipped with 4 available screens if needed, with one that's quite large. And as it turned out, during my hearings, I used only that one large screen with the video platform displayed on one side and the real-time transcript on the other. I generally opted for the hard copies of the documents. The bundles had been couriered to me by the parties in advance. So my hearings and those of my colleagues have proceeded smoothly without any significant delay. We did all participate in trial runs. That was essential. Everyone was asked to reserve flexibility at the end of the day in the event of technical difficulties. We wanted to be sure we could make up any lost time. And that happened on certain days, and that kept us on schedule when we made up that time at the end of the day. I would say the most difficult thing to manage has been the difference in time zones. I think Nigel mentioned that. It's not easy to find a sufficient number of overlapping hours without overly burdening any one party. But I think the solution there is for people to be more flexible about their work hours. And I think we're all doing more of that anyway, now that we're at home, and the traditional barriers between home and office are not what they used to be. The hearing that I had was with parties all in Asia, and so I started the hearings at 5 p.m. My time here in California. When compared to the wear and tear of travel and having to travel to a different jurisdiction, adjust to a different time zone for a physical hearing, it's actually not so bad. And it's easier to stay in the comfort of your own home. So while it's a different experience to be in a virtual hearing, I think with appropriate planning, it gets the job done. In fact, and this may be a little controversial, but I would say that in some circumstances, not all, the question may not be whether virtual hearings are as good as in-person hearings, but whether they may not be better. And to be sure, I've seen parties in my own cases and in some of the corporate counsel discussions that we've hosted voicing opposition to video hearings. And sometimes I believe the protest is tactical, an effort to delay or to try to create risk of a potential challenge. Sometimes it seems like a psychological barrier or just the simple lack of familiarity with what it's like, what it looks like and feels like to cross a witness by video, or for an arbitrator to observe a witness by video. But when pushed to explain that objection, what we're typically hearing is that in order to assess credibility, the witness needs to be in the same room. And I can imagine that might be true in some circumstances, but I could easily argue the other side of that, particularly from the arbitrator perspective. It may seem a little counterintuitive, but I found during my virtual hearings that I could enlarge the image of the witness so that from shoulder up, the witness was basically life-size. And I could study the witness's body language and facial expressions on video more closely than I could in person. And then in all events, some say that many of us overestimate how well we can read someone we don't know, particularly when we're not aware of certain nuances, cultural nuances of expression. I don't know if you're familiar with Malcolm Gladwell, but he seems to take that view. So one thing we might consider is whether we attach undue importance to the question of where we need to be to better assess credibility, because it may be that we're not that good at it in any setting. So I pose that as a question, and I'll stop there and save some other thoughts for later in the program.
So thus far, it seems to be a fairly resounding set of affirmations of the value, the doability, certainly, of virtual hearings. Any dissenting views? Fabiano, what's your experience at Sergio Bermudez? Have you had the same sort of positive experience, or do you have concerns, questions about our new approach towards hearings?
Hey, Gary, thanks. Thanks very much for organizing the event, and good morning to everyone. I do have some concerns. We have been facing that in some cases. One of that clearly, as you anticipated in your article, is the time zone issues, as everyone is raising. We do have an arbitration hearing that's supposed to take place between a Brazilian party and a Korean party. It's a 12 hours time difference between Brazil and Seoul. And it's we are having a hard time to organize that. Plus, there is also the translation issue, which slows down the proceedings. So there are some issues. From our perspective, I don't think that scheduling the hearing itself or scheduling a virtual hearing itself would generate any risk of a set-aside proceeding. But if the party, the big risk here is to guarantee that the party will have the opportunity to present this case, because then if you don't have that, that is where you have the risk of the setting aside proceeding. And the organization of the hearing is the most important for this. Like what we have seen, in order to make it work, you do have to spend a lot of time with organization of the meeting, particularly in these cases with different time zones, the need of translation. And I know that there is almost when someone suggests to schedule a virtual hearing and one party somehow shows some kind of opposition to that or some concerns, it's almost as if the party is trying to procrastinate the proceeding. The general feeling is almost immediately that, well, when the party raises some concerns. But I do have some concerns with witness statements through virtual hearings. And I've been researching about that, and this is nothing new, honestly. When you look at criminal courts and criminal proceedings, they have been using witnesses' deposition through video conference for a long time. This discussion has already appeared a while ago in criminal proceedings, especially to avoid the risks and the costs of transferring people from jail to courthouses. So these so they have already been used. And I look, there is a law in Brazil from 2009 that governs that, establishes some rules for that. And they established that it is an exception, for example, that hearing through video conference is an exception, and also establishes that the parties and the court, they do have the right to inspect the place where the room where the witness is gonna present its deposition. I know that, as Maria raised, I know that very experienced arbitrators, they do have a capacity to identify and have the feeling of whether the witness is saying the truth or not. But by the same token that technology comes to help us for the hearing, technology also exposes us to have some kind of problems with witnesses having access to hear, for example, the depositions of previous witnesses, or to contact with the lawyer without any kind of control. So there is no doubt that the hearings, they are gonna happen virtually, and this is something new, and it's gonna be very good for saving costs and time. But particularly with factual and technical witnesses, I do think that we cannot oversimplify the risks that someone might be breaking any kind of a rule on talking to the witnesses. This was something already difficult in a physical hearing to control. But with the virtual hearing, I think it gets even more risky, and we have to be careful with
that. That's very interesting, very helpful. What are Brazilian courts doing, Fabiano? Are Brazilian courts going ahead in urgent cases with virtual hearings or in-person hearings? Are they going ahead in all cases? What is the approach in local litigation? Question for both Fabiano and Karina.
Here in Brazil, we do have a court system that is quite already, there's a lot of technology. 80% of the total court proceedings in Brazil are already virtual. They have everything online, 80%, 80. And in the highest courts in Brasilia, 100% of the cases, for example, the Supreme Court, 100% of the cases are online. The cases are going forward. There is a lot of decisions, like it's pretty standard the way they are going. Some courts are even more efficient because there is no interruption from lawyers that come to talk to them. But the injunctions, for example, they are also analyzing. There are hearings to present the case, like in appellate courts, virtual hearings in which the court appears and you present your case, but it's like the party presents a case for 15 minutes and then they judge everything online through the YouTube. So there's a lot happening. The only thing that I haven't seen too much, and Karina can add, I don't know if you had that experience, is hearings on the merits. On civil and commercial cases, I haven't had any case yet in which there was a virtual hearing to hear witnesses and or either technical or factual. But except from that, like the courts keep on working, I would say, almost regularly.
Yeah, I didn't have a witness cross-examination before courts. We had trial online sessions already in which we could present our cases verbally. And one thing that I was even discussing with Eduardo Zuleta that is a big concern in Latin America is the fact that courts are adjourned or closed in many countries in Latin America, and this could have an impact in arbitration, especially for those that need to file a annulment action and have the statute of limitation issue. In Brazil, it's 90 days, or even enforcement measures or injunction requests in support of arbitration. But in Brazil, because the judiciary was already so familiar and well prepared for remote sessions, we do have that. I had one session, one hearing in an injunction phase before court, but it was not with witnesses' testimony. It was just arguments from the lawyers.
Eduardo, a view from Bogota. I'm sure that as one of the most in-demand arbitrators in Latin America, elsewhere, a member of the SIAC panel, you've had experience with remote hearings. I'd be interested in your view from the other side of the table, so to speak.
Okay, thanks, Gary, and for the invitation. And it's a pleasure to be here and with all my colleagues and friends in the panel. I think my experience, we have all had technology used in arbitration before. What this has done is to accelerate the use of technology. You remember shortly before the pandemic, a number of institutions urging arbitrators to forget about hard copies and use soft copies, urging arbitrators to forget about hard copies and accept the uploading of the file as opposed to receiving 15 boxes with papers. Counsels proposing to arbitrators to use iPads in hearings. Counsel challenging or refusing to cross-examine a witness when the witness could not appear, and the other party was asking the witness to be cross-examined virtually. And this basically has accelerated that. we all, one way or the other, had the technology. We, one way or the other, had some experience in the matter. But in my view, there are certain things that we had to learn from the point of view of the arbitrator. Number one, multitasking, because it's not the same being in a room where you can basically look at everybody from your seat, as opposed to being seated in front of a computer where you have to look at 15, 20, 40 frames different with faces, and then an iPad with your file, and then probably a computer where you're seeing the documents that are being presented by whoever is making the presentation, plus the transcripts. So you'll be looking at the same time at 4 things, trying to guess reactions that are not the same that you have in a room. Just to give you an example, when you're watching a cross-examination or the examination of an expert, by the reaction of some of the counsel, you know whether the question was a key question, was a bad question, was a good question. Here is almost impossible to look at that reaction. And I would agree with Maria that you have to start looking at things and at people's reaction in a totally different way. So that's one thing that I'm seeing. The second thing that I'm seeing is that when arbitrations are conducted more in a civil law style, probably the difficulties are less. When you see the jurisdictions in Latin America where you have a dualist approach to arbitration as opposed to monist approach, Mexico has a monist approach, and Chile has a dualist approach. And in Chile, when you look at local arbitrations in Chile that are conducted under a more civil law approach, then the problem of the cross-examination of the witnesses and all that sort of thing you don't have. So maybe in local arbitrations, they are having less problems than in international cases. And maybe one of the things that we will see as a result of this situation is a change in the way we do arbitration, particularly in Latin America, I would say, in the sense that we need to realize one way or the other that this is not simply let's do by Zoom what we normally do in presence and do not change anything else. I think we need to adapt a number of features in the arbitration. We need to adapt to the communication between arbitrators, to the communication with counsel, and to the use of this technology. Things I think are not going to be the same in the future for arbitrators. Things are not going to be the same in the future for counsel. And I think to some extent, the use of technology is here to stay, and the virtual hearings are here to stay. I see, for example, that, I don't know, first sessions in exit cases, we're not going to be present anymore. There's no need to do a 2-hour, 3-hour hearing to discuss mainly procedural issues and have a bunch of people traveling to do that. Same in same procedural hearings where you don't have witnesses, you don't have experts, you simply have to discuss procedural issues. I see users less and less convinced that you need to do a lot of traveling and a lot of paraphernalia to do a merely procedural hearing. So my reaction and my thinking at this point in time is that this way of doing things is here to stay, at least partially. I don't think that this is going to replace hearings in presence. Hearings in presence have a lot of advantages in terms of communication with counsel, communication amongst arbitrators, looking at people's reactions, deliberations. You know that in normally you have deliberations basically at the end of every day of the hearing, which is not the same as when you're connected virtually. But we're going to see in the future, I would say, from the point of view of the arbitrators, a mixture of virtual and presential hearings. But the way we do arbitration today is I think it's going to change, and it's going to change for good.
Interesting thoughts there from Bogota, not just about the present, but also about the future. I suspect everyone would agree that the traditional in-person case management conference or first procedural meeting or first meeting of the tribunal is very likely in the future to be virtual. There's some treatise, I forget what the name of the treatise is about international arbitration, but it expresses the view that it's essential for your first procedural meeting to be in person so that the tribunal can bond with the parties, so that the parties can have confidence in the tribunal. I suspect that is going to be seen as a historical relic, a little bit like a peppercorn as consideration in the common law context. But the case management conference, the first procedural meeting, in a sense, isn't the hard part. The hard part is, as I think all the various panelists have suggested, the hearing itself, the trial, if we can put it that way. Let's talk about the different parts of the trial, because again, a hearing isn't all the same thing. A hearing is actually pieces of different things. You have openings, you have cross-examination, you have fact witnesses, expert witnesses, you have procedural skirmishes. As Eduardo very rightly points out, you also have deliberations. It doesn't involve everybody, but importantly, it involves the people who will actually make the decision. You have closing statements, you have other things, you have site inspections. How are all those different things going to work? How do they work right now with remote hearings? Let's talk for just a moment about opening presentations. Perhaps we can start with Nigel and Maria from more of a common law perspective. What do you do about openings if you're doing this virtually? Do you use a PowerPoint the way perhaps you would have in the past? How do you use it? Do you adjust it at all given the new procedure, the new setting? Perhaps start with Maria, then Nigel.
I think less usage of PowerPoint is better in virtual hearings. That's what I'm seeing, and that's what we're doing. Because we're not all in the same place, there's less engagement generally. And then if you put up a piece of paper on the screen rather than an image of a human being, I think that you tend to decrease the engagement even further. So what I'm seeing is less in opening statements, less of the PowerPoint focus, which I think is a good thing. And I know you didn't ask yet about this, but I do want to say on cross-examination and really throughout the hearing, it functions more smoothly if you've couriered hard copies of things to all the parties in advance. Where I found that we had most of our technical difficulties, it was where people were trying to put something up on the screen, share a screen, show an electronic document. I know some people like to have a separate screen where they go to hyperlink documents. I found everyone was able to get on the same page more quickly if we were working with the hard copies.
Nigel, are PowerPoints one of the relics of the past?
No, I think we've become too dependent on PowerPoints. And I think certainly from my perspective, when sitting as arbitrator, I do find it helpful to have a physical sort of synthesis of what the parties consider to be the key points at that stage of the case. I mean, we will plow through the pleadings, but I think ultimately to see the way a party decides to make its opening is very helpful, because things may have fallen by the wayside a bit in one party's case as a consequence of the exchange of pleadings, and you don't get a sort of a summary pleading that deals with the whole case. So I think the opening speech is always a helpful way to focus minds, both for counsel and for the arbitrators. There's been some discussion about whether or not we could have recorded openings, that in essence, that each party records a presentation, that gives the panel members the opportunity to look at it, to pause, to think about it, and to come to the hearing better prepared, in the sense that they understand what the key points are, perhaps reflect a little bit more rather than going straight from, as you would in a live hearing, straight from the openings to the first witness. I must confess, I'm a little concerned about that because I think there should be a dynamism in the way that openings work such that arbitrators should feel free to stop parties and to ask questions at appropriate junctures, which is lost. There's also a loss of an opportunity to control content by the other party. You know, one can imagine that a less than scrupulous counsel would seek to put in some documents that weren't on the record or were questionable, or there were some privilege issues. So that worries me a little bit. But I do think the principle's interesting, that perhaps one of the benefits of being remote is that you don't need to do everything in a single block. And I think this equally applies to closing statements. You know, when everyone spent a fortune getting to a particular remote location, of course, everything has to be done as quickly as possible, and you know, and one thing after the next. If you're doing it remotely, you know, I think consideration should be given to, you know, have a day for opening presentations live and in this kind of format, and then perhaps have a day of pause for the arbitrators to reflect, to think, but actually for each party to reflect on what the other party has said, so they can refine the way in which they're going to conduct cross-examinations and say, well, actually, the way we thought about this with the draft cross isn't actually that important anymore, because once it's kind of there and you're already in the running, you kind of lose that opportunity to actually respond to the case as it's moving quite as flexibly as you might want. So maybe thinking about having a day, perhaps a day's pause, and then continuing, and allowing the tribunal to perhaps raise questions following that opening. We always use the questions following the hearing, but actually the most useful time to receive questions is almost, you've seen the pleadings, you've heard our opening speech. Is there anything here that you would like us to particularly focus on as we go through the examinations of the witnesses? So that's the other issue. And just the other thing is just timing. Again, I think the sort of the 3-hour opening, it becomes very hard to concentrate for 3 hours on a video screen. One case we're doing where we've got a kind of an option because the hearing is down for November. We don't know whether it's going to be virtual or in person. And we're going to make a decision in September as to which way it goes. But we've now got 2 versions of the opening speech: the virtual presentation, which is an hour shorter than the in-person presentation, because we think we're just going to need to get to the key points quicker to maintain the interest. It's just concentrating on a screen is, for whatever reason, much more tiring than being in a dynamic sort of human environment. I think that's and again, maybe to do with time differences as well.
I'm going to want to move to, if I can put it this way, a civil law perspective from Karina and Fabiana. But before we do that, just pausing on what Maria and Nigel said. I think Nigel's description of the same case, but in 2 different settings, one remote, the other in person, and how he would approach it as counsel is very interesting. You're using a PowerPoint in both? You envision using a PowerPoint in both? It's just in one, it would be an hour shorter?
Yeah. But the PowerPoint will be materially shorter in the virtual hearing. Going back to what Maria said, I think ultimately, when you've got a speaking head and you're trying to look at a PowerPoint and there's not a dynamic sort of human environment, I think it's good to capture the interest through an oral presentation. But inevitably, with technical cases, it's helpful to illustrate key points. But I think some of the sort of the breakdown of the case by bullet points, slide by slide, gets dropped in a virtual hearing, whereas the graphs and the sort of visual things that help the tribunal to understand a concept visually stay. So at the moment, the set of interest, I mean, our virtual presentation is about half the length of our in-person presentation.
It's interesting. Do you worry as counsel that if it's an hour shorter and materially shorter in terms of slide presentation, do you worry that you're not really communicating the same level of detail?
I think the tribunal needs to be, perhaps, it needs to go to the tribunal. I think ultimately, one hopes that you have a well-prepared tribunal, but in a virtual hearing, I think it's even more important that the tribunal prepares well, because without that, you don't have that luxury of of that personal interaction or that immediacy. So I think if you, as an arbitrator in a virtual hearing, there's no sort of shortcuts. There's no sort of, well, I'll rely pretty much on what the opening is. The opening has to be much more focused on the key points, assuming there's a fairly deep understanding of the underlying facts. I mean, ultimately what gets lost, I think, in a shorter presentation is the development of the underlying facts. And you assume that that's been understood, and you go straight pretty quickly into the key legal issues and the key damages issues without dwelling too much on the story. But this is all experimental, and I think we'll have to see how it goes. The direct experience is the same hearing we had, where we sort of had half in person and half virtual. So that was we're kind of learning as we move forward.
Yeah, but I think it's really interesting for all of our numerous participants to sort of see live from one of the leading arbitration practices, not just in the Americas, but the world at Freshfields, how they're thinking about presenting their cases in an opening, both in a in-person and a virtual setting, and how it might differ. Karina and Fabiano, your reactions from a civil law, from specifically a Brazilian perspective. How do you approach openings?
Should I move on? Well, I would just comment that I had a hearing in which, in the end, we chose, as Nigel said, to record it firstly. There was some, in the beginning, was a little bit of prejudice because, well, the arbitrators may not watch the recording, the full presentation, but we chose that instead of doing a shorter online presentation, and of course that the opposing party received the recording at the same time that the arbitrators, and in the end it worked well because arbitrators, the first meeting, the first day of the hearing was already with questions from the arbitrators. And in the end, during opening presentations, the interaction is a little bit not as usual. The arbitrators and co-arbitrators do not interfere and interrupt the presentation most of the time. So I think that they had the time to think a little bit on what was the presentation. And we didn't want to miss the opportunity to put our full arguments there because it was actually the first opportunity to present our full case before the witnesses were heard. So it worked well. Also, there is a difference because in the civil law perspective, we do much more open questions during cross-examination. We do direct examination, and it gets more tiring as well. And one tip that I would suggest to the parties to counsel when it comes to cross-examination, and then you have to use documents, and you plan in advance, of course, your full cross-examination, and then you do the PDF of all the exhibits that you will upload for the witnesses. So you just choose the page that you know where that document is, and it goes much faster. It's much easier instead of uploading each document in advance.
Fabio, your view from the same jurisdiction.
I think that for opening memorials, we do have to make some adjustments. It is not the same, and we cannot think that it is the same to speak in a room with everyone making the presentation there, where you are standing and going through the room if you want. And it is completely different to do it sitting in front of a camera. So it needs to be very well prepared, because it makes a difference. And also it makes a difference to keep the attention of the arbitrators. having someone sitting there for 1 hour, 1.5 hours, looking at the screen, you really have to make some adjustments in order to keep people interested in paying attention. Like, for example, speaking slower, still using PowerPoint, but you have really to rethink the PowerPoint. That is one thing that we have noted. Like, for example, complex PowerPoints with movements, sometimes it's difficult. They might not work perfectly online. Of course, we do expect that this is going to be improved. We are just beginning to use these tools. But if you use too many slides and with some movements, you might get into trouble, or people might not be able to follow what you're doing. But another big concern that I have, and Nigel has mentioned that, is the dynamism between parties and arbitrators. If parties are usually concerned that they do not know what is in the mind of the arbitrator sometimes, that what are the issues that are important for arbitrators, with the virtual hearings, this might be even increased, this concern, because when you're doing the presentation, for example, you notice not only with the questions as Nigel has raised, but also with the body language, the interest of the arbitrators on a certain issue that you're raising, a certain part of your presentation, or even the body language of the other party, the other party's counsel. So this is something that it's going to be more difficult to identify when you have a virtual hearing, and particularly with the arbitrators, like the distance and being like becoming a black box that you don't know what is in their minds and what is important, which are the arguments are important for them. This is an issue that we should pay attention now with virtual hearings.
That's very interesting. Before we go back to Eduardo to get the arbitral tribunal's take on these various points, let's stop and let's pause for a moment and think about a couple of the things that we've heard. The notion of a pre-recorded opening that Karina, based on the experience at Ferro Castro, suggests does solve some problems. If you pre-record your opening, then time zones aren't obviously the same sort of issue that they might be if you have live openings and someone has to get up at 4 a.m. in the morning the way that Maria did today. On the other hand, it really does turn the opening really into another kind of written submission. It might be a read written submission, but it's still a written submission, and you can't really be sure that the arbitral tribunal is going to read it. And perhaps more importantly, as Fabiano says, the tribunal becomes even more of a black box. Obviously, you don't know what they're thinking as you're pre-recording your hearing. Eduardo, how do you respond? How do you as an arbitrator respond to both, if I can put it this way, live virtual openings, but also whether or not you've actually had them presented to you? How would you see a pre-recorded opening? Good thing, bad thing, doesn't really matter.
Yeah, we've been in at least one case, we've been presented the option of the pre-recorded opening, and it has raised a number of questions. Number one, how should it be presented? Should it be submitted simultaneously with both parties? Normally, respondent would complain to that and say, in a live scenario, in a present scenario, I would always have the option to listen to what the claimant has said and then react to that in my opening and respond to some things. Number two, counsel, in this particular case, when we're debating the thing, the position of one of the counsel, and I think it was reasonable, is to say, well, I would like to see the reaction of the arbitrators while I'm presenting the thing. I would hate to see a situation where an arbitrator is alone by himself, listening to whatever presentation I made, maybe not at all in sequence, but in cutting the presentation in listen to 15 minutes and then go to do something else and then listen to an additional set of 15 minutes. So counsel are reluctant to do that. And from the point of view of the arbitrators, I think that it would work to the extent that the entire tribunal would look at the presentation at the same time, which is something that is impossible to achieve if you simply receive the recording thing. That's one point. The second thing that we've seen in the openings, that to say that my preference would be to have the opening in live, not pre-recorded. The second problem that we've seen is that there are certain platforms where you cannot see other than the PowerPoint and the individual who's presenting the PowerPoint. You are not seeing the rest of the counsel, you're not seeing your co-arbitrators, and that is, to me, is a problem. I don't remember if it's WebEx or that there's one particular platform that is being used where all you see is the counsel and the PowerPoint. That's it. And so that again, from the perspective of the arbitrators, I see as a problem because you lose sight of the reaction of your colleagues. You lose sight of the reaction of the counsel from the other party, counsel from the party who's making the presentation. So I think that is also a problem, and counsel and arbitrators should be very much aware of which kind of platform to use if you're going to use PowerPoint. And there are platforms that are friendly for that or that are not. And the third issue that Nigel addressed that I think is important is that in this sort of midstream situation we're in, where we hope there will be hearings and presence, but we don't know whether and when, we have to prepare for both scenarios. And that is a difficult task. When you look at a procedural order, the traditional procedural order for a traditional hearing in presence, and you look at what you have to do as procedural order for a virtual hearing, it's totally different. And you have to deal with a number of details and a number of issues. And counsel and arbitrators today would have to work twice as much as normally because they would have to prepare for both. And then, as Nigel was saying, a month or 2 months before the hearing, make a decision. And that's going to be a situation for a number of months, I foresee. I asked a question in a forum last week in ITA as to what was the view of US practitioners as to when realistically we could have a hearing in person, and the most optimistic view was 6 months. So we are now in a situation where planning is difficult because we need to plan for both, and planning for both is substantially different. But just to sum up, if I was asked as arbitrator, my preference would be to have a live presentation as opposed to pre-recorded one. And PowerPoint is useful to the extent that the PowerPoint is focused on the key things of the arbitration. If the PowerPoint is a 400 slides PowerPoint just to give you from day one of the issue to the very last day, that it's totally useless.
It's very, very helpful. Very helpful.
And it would, yeah. And the PowerPoint, as to take in on Nigel's last point, I think that the presentations in a virtual hearing would have to be more concrete, more to the facts of the case, more to the key issues of the case, as opposed to the traditional 3-hour opening where you basically deal with everything. You have to be more concrete, you have to be more specific. And the arbitrators, there's a very important point, the arbitrators need much more preparation for a virtual hearing. You cannot just go to the hearing and try to learn from your colleagues or from counsel or from the other arbitrators in the hearing. You need to go to the hearing knowing exactly every single detail of your case as an arbitrator. Otherwise, the virtual hearing and the virtual opening is not going to help.
It's very interesting guidance from the arbitral tribunal's perspective. A decided preference, I think, like the preference of most counsel for live openings as opposed to something recorded, an opportunity, both for the respondent but also the claimant to hear in real time your counterparty's presentation, to see the tribunal, to, even if the tribunal may be reluctant to ask questions virtually, to at least have the opportunity to see their facial expressions, hopefully get questions from them. One point that Eduardo makes, I think, really underscores the importance of the arbitral tribunal, which is, if virtual hearings are necessarily shorter, more to the point, if it's harder to cross-examine, if your opening will be materially shorter, and it's essential the tribunal prepares and prepares well, then our choice as counsel of who the arbitral tribunal is becomes even more important. It's often said that the most important choice that you make in arbitration is your choice of the arbitral tribunal, your choice of the arbitrators. But if what the arbitrators do on their own is even more important in a virtual world, then choosing arbitrators who you have confidence that are actually going to do that, as well as be able to master the technology, is critically important. In that regard, new tools like arbitrator intelligence, which enables you to review past experiences with tribunals and to get hard data as opposed to anecdotal impressions, may become even more important. We have now about 10 minutes left before our appointed end time. We promised that we would address some questions from the participants, and we have a few. Perhaps we can start from a common law perspective, but one of the questions, switching from practical presentation experience to a little bit of law, is how do virtual or remote hearings affect enforceability? I think we can put to one side enforceability of the award. I think we can put to one side those cases, and there are a fair number of cases. The case that Karina and Nigel were involved in is a good example, where both parties consent to agree to a virtual hearing. But suppose one party doesn't agree. Suppose one party says, rightly or wrongly, that the arbitration agreement, the institutional arbitration rules, entitle it to a physical hearing and so-called in-person hearing. Or alternatively, suppose that they say that whatever the agreement might say, they will be denied, as a practical matter, an opportunity to be heard. Can an arbitral tribunal go forward and conduct a virtual hearing? Looking at this from a North American and perhaps English common law perspective, if the tribunal does that, is the award subject to, is it exposed to the risk of annulment or non-recognition? Perhaps we start with Maria, who's got her mic off, and then turn to Nigel.
My view on this, Gary, is that if the challenge is based on the virtual modality itself, it's not a real risk in the US and in most jurisdictions. And I understand that there may be a small number of jurisdictions where the law may present an issue. But certainly here in the United States, judges are conducting their own trials at all levels of the courts virtually. And it stands to reason that a judge conducting her own trials through video, as is the case, is not going to be receptive to an argument that doing that in arbitration is a due process violation. Now, that's not to say that, as with any hearing, one couldn't imagine the execution of the process, creating some inequality, but that's a different matter. I've had some cases, I actually have one now, where a party is objecting to proceeding virtually. Ironically, it's a case where the rules presume a virtual hearing, an electronic hearing. But the parties earlier on in the proceedings prior to the pandemic had agreed to a physical hearing. And now one of the parties is refusing to move forward virtually. And again, we don't know the decision yet of the arbitrators, but there have been threats of challenge, and I just don't think that's a real risk. Not in the U.S.
What about some institutions' rules? The ICC rules provide that if requested, the tribunal shall conduct an in-person hearing. The ICC also has guidance in its notes that give the tribunal discretion to use other forms of technology, video conferencing, and so forth. But what about rules that require an in-person hearing? Is that a problem?
I don't think so. I think that a virtual hearing like the one we're having is arguably in person.
We're in person right now.
We are in person, yes.
Nigel, your view from across the Atlantic, or well, no, I've got you in the wrong place as usual. If this can be a geographical place, your English view from Washington.
English view from Washington. No, I mean, I share what Maria said. I think it'll be a very, very hard call, just relying on the fact that the hearing is virtual, particularly given the extreme circumstances under which we're operating and in which most court systems, including the English court system, are largely working virtually. I think that's very hard. I think the more subtle question will be, what if a tribunal decides to say, look, we've only got a week allowed for this. It's now got to be virtual. We're going to have half the amount of time. Therefore, you pick the two witnesses you want to cross-examine, and that's all you're going to have. Or you're going to have to make your presentation at 3 a.m, and the other side gets to make it at 9 a.m. And the one party objects and says, look, we're going to be half asleep. Nothing's going to work well at that stage. You won't have I don't know, whatever. Those specific decisions, I think you need to be very careful of in a virtual hearing to make sure that parties feel that they're being treated fairly and equally within the virtual hearing context. But the mere fact of the virtual hearing, given the technology that exists today, I would be very surprised that any sort of well-known judicial system of respected seats would take that argument in and of itself as sufficient to set aside an award.
No. Before we move to Karina and Fabiano, there's sort of a couple data points and observations. One, I understand that in China, absent consent from both parties, you cannot have a virtual hearing. One needs to have both parties consent if you're going to conduct things remotely. If you do have both parties consent, then it's not a problem, but either party has a veto right. Whether that is an entirely accurate observation, whether it applies to international arbitrations seated in China, much less elsewhere, are more complicated questions. But there are at least some jurisdictions where I think there's greater skepticism. There are German commentators from before the pandemic who took the position that the model laws requirement in Article 24 for a hearing meant a traditional form of hearing, a hearing where we were all in the same room, and if a party requested that, it was entitled to that. Karina and Fabiano, your thoughts from a civil law perspective on this issue, the question of whether an award's enforceability is endangered if one goes forward with a virtual hearing over one party's objection.
Yeah, so as I mentioned in the beginning of my presentation, Gary, because if Brazil is the seat and the governing law of the arbitration is Brazilian law, then the concerns that maybe like China, there would be a prohibition of virtual hearings or express reference to physical appearance. This doesn't exist in Brazil. Also, the arbitration law gives power to the arbitrators to conduct and to choose the procedural path, including taking evidence. And then because also the judiciary is already acquainted with virtual hearings and have regulations on that, I think that there would be no issues on enforcement. Of course, that the concern is whether the party has, both parties have equally the ability to present their case. They have access to technology. The witnesses would be able to have access to technology. And most of all, the arbitrators should write a grounded decision, detailed decision that says that they have approached all these issues. They have dealt with all these issues before moving on if there is no consent among the parties. It's interesting, probably you have seen that, but the Egyptian arbitrator, Mohammed Wahab, he has published at GAR a pathway on what considerations arbitrators should follow, like a decision tree on once you don't have consent. I think it's a nice tip to take a look at.
Fabiano, just very quickly, we'll then have time for one more question.
Yeah, I agree with Karina. I think that in accordance with Brazilian law, scheduling the virtual hearing by itself would not constitute a reason to set aside. The only matter is that you have really to organize everything well to make sure that the parties do have the opportunity to present their case. If you look at the New York Convention, one of the reasons for denying recognition of the award is that the party did not have the opportunity to present his case. And this is also a reason for a set aside proceeding here in Brazil. So if you do not organize properly, that might be an issue. And everything is much easier when we talk about the level of professionalism of the firms and the arbitrators that are participating in this hearing, in this seminar here. But at least in Brazil, with the expansion of the practice, what you do have is many law firms that are beginning to act in arbitration, and new arbitrators also might not be so experienced, and we might have problems if they do not take a lot of care. When there is this level of professionalism, it's much easier to deal with that.
Yeah, that's true as in this context as in others. Just very quickly, a final question perhaps for Eduardo. Special tips, any tips at all, in fact, for dealing with virtual witness examination of a remote witness, if, in the words of the questioner, there's simultaneous translation? How actually would one conduct remote testimony if you had simultaneous translation, or is that just not doable?
It is doable, but it is difficult. I've seen a number of cases in which it has been decided that the translation is successive and not simultaneous, simply because of the difficulties of having the translator acting as in a normal in-presence hearing. It is doable, and there are tools to do that, but it's not an easy task.
I guess you need separate,
just one final comment
channels.
on the prior issue yeah, that is correct. And one final comment on the prior question. I think that's going to affect the selection of venues in Latin America particularly, but elsewhere, where the courts decided to close, that Karina was mentioning at the beginning, where the courts decided to close because simply the courts think that if it's not in presence, it's not doable, then they will treat the awards and the decisions of the arbitrators in that venue the same way. If it's not in presence, then it's not doable, then it may be a cost or annulment. So you have to be very careful in picking your seat from now on and have that additional consideration.
Yeah, that's right. And I appreciate that observation very much. I think it's very good. It's important these days in particular, not just to choose your arbitrators well, but to choose your arbitral seat well. It falls to me to do two things. One is to thank our panelists. I think it was I know everybody has webinar fatigue these days, but I think this was an exceptionally well-prepared panel, and I'm sure like the various participants learned a lot from this presentation. I'd like to thank you all, Karina, Fabiano, Maria, Eduardo, Nigel, for taking the time to share your experiences. The second thing that it falls to me to do is to make an advertisement, a commercial break. Life at SIAC, the Singapore International Arbitration Center, goes on even better than before. Some people ask whether winter is coming to international arbitration. Actually, I think the right question these days, picking up on something that Maria said, isn't summer coming? National courts in many major jurisdictions are closed or closed to all but urgent matters. Once they reopen, when they reopen at some indefinite point in the future, we can anticipate that many of them will return to the practices of the past, namely expensive in-person proceedings, which will be the focus of domestic proceedings and therefore international ones. International arbitration has learned. We've learned not just how to conduct case management conferences, but also other aspects of the arbitral process remotely. By and large, that will be cheaper. It'll be more efficient. It'll be easier to resolve disputes the way that businesses expect them to be resolved. I think that the economic dislocation caused by the pandemic will, and already has, produced more, not fewer disputes. SIAC's case numbers are up on the order of 25% as compared to last year. I think the real question that we face is, how will we efficiently deal with summer coming, with the increase in the caseloads, the number of disputes that parties expect us to resolve well? To get the answer to that question, tune in to the next SIAC webinar. Thank you all very much again.